Law 578, Law of Evidence 2, Lecture 3, Witnesses, Competency, Compellability and Privilege. Assalamualaikum warahmatullahi wabarakatuh. Okay, in this video we are going to continue with issues of witnesses which relates to competency, compellability and privilege. In our previous discussion, we have looked into issues related to affairs of state, which is discussed in section 123 of the Evidence Act. And today's discussion is basically perhaps continuation of matters related to affairs of state, where we are talking about official communication. Let's look at section 124 of the Evidence Act. Section 124 of the Evidence Act states that official communications, no public officer shall be compelled to disclose communication made to him in official confidence when he considers that the public interest would suffer by the disclosure. Right, under section 124 here, we'll find that you are talking about information or communication made to public officer, and this information is regarded to be an official confidence and cannot be disclosed. Now, the rationale as to why this provision is as such is actually for public policy. Say, for example, you have a communication made to maybe an enforcement officer during investigation. Non-disclosure of this communication may be to protect against tampering of witnesses. Nonetheless, even though it may be regarded as privileged communication, it is, however, for the court to decide whether the communication made by an individual to the public official here is regarded as privileged, where the court actually is empowered pursuant to section 162 subsection 2 of the Evidence Act. You have that in the case of Lee Loh Kah Keng, whereby what happened in this case is that there have been issues relating to a communication made to a police officer, and whether this particular communication is privileged or not, the court held that communication has to be regarded to be official or not depending on the court's making the decision. What the court got to do is basically, number one, either to look at the official communication itself to determine whether it is privileged or not. If the official communication itself cannot be referred to, then the court can refer to any other communication that refers to this official communication. So basically, the operation of section 162 subsection 2 of the Evidence Act here is very much similar when you determine affairs of state. So you're talking about the court here having to look into the communication or any other related communication that may affect this official communication. Now, so what are the elements that you got to see? So under section 124. So basically under section 124, you are talking about official communication. What you got to prove, number one, is that there must be public officer. Right? So you have here, perhaps, a witness here, a person here, W, is making a communication to a public official, and this particular communication is the one that maybe D here wish to disclose in the court. So the issue now, whether the public official can disclose the communication that he made with W. So that is what it meant by official communication. So the first thing that you have to establish is that this communication is actually to public officers. Okay? The second element that you have to prove is that whether the communication between W and PO here is actually made in official confidence. So you have second element here, the communication must be made in official confidence. So if the communication is made publicly with no intention of having any official confidence, then the communication is not to be regarded as privileged under section 124 of the Evidence Act. Okay, Now, you can refer this in the case of Datuk Sri Najib Razak against public prosecutor. Now, what happened in the case of Datuk Sri Najib Razak and public prosecutor is that, so you have here MACC officer. So the police officer, the public official here is the MACC officer. And the communication is actually made by, in the case of Datuk Sri Najib, so the communication was actually made by the witnesses, those who have been investigated by the MACC officer. So what happened here is that during investigation, this witnesses has disclosed quite a lot of communication with the MACC officer. So the issue here, and among them will be maybe the name of the witnesses and things like they communicated. What happened here is that the defense counsel, that is the lawyer for Datuk Sri Najib, is inquiring to the court for the MACC officer here to disclose the communication that he made with W. So in this case, the court says that, right, statements made by witnesses to the MACC officers are made in official confidence. This is a statement made in accordance with, it is a statement made in official confidence for the purpose of investigation. And according to the case, the court says that this communication is an official confidence and therefore should be privileged under Section 124 of the evidence to prevent from the possibility of tampering of evidence. Yeah. So that is an example of an official communication. So you have that in the case of Datuk Sri Najib Razak. This is a 2020 case. Yeah. Right. However, yeah. So meaning to say that if there is a communication between these two individuals, it will be privileged. However, there's a proviso under Section 124. So you have the proviso here, whereby it says that provided that the court may inquire the head of the department of the officer to certify in writing whether or not such disclosure would be detrimental to the public interest, and if the head of the department certifies that such disclosure would not be prejudicial to the public interest, then the officer shall disclose the communication. Now, this particular proviso basically giving the power to the official of the states or the head of the department to certify in writing that this particular disclosure is actually in public interest. So this is basically an authority given to the executive here to have the power to basically indicate that this is actually to protect public interest. Okay, so that basically be a discussion on communication, official communication under Section 124. Now let's look at the continuation of this one. So the next provision that we are going to look at will be professional communication. Right? Professional communication is actually provided for under Section 126 of the Evidence Act. Right? Now let's refer to 126 here. So you have official communication. No advocate shall at any time be permitted, unless with his client's express consent, to disclose any communication made to him in the course and for the purpose of his employment as such advocate by or on behalf of his client, or to state the contents or condition of any document with which he has become acquainted in the course and for the purpose of his professional employment, or to disclose any advice given by him to his client in the course and for the purpose of such employment. So basically, Section 126 subsection 1 here provides you protection or privilege in professional communications. Professional communications referred to here will be the communication between the advocate and solicitors with his or her client. And the kind of communication that is not allowed to be disclosed is that you have three kinds of communication. Number one, communication, any communication made to him by his client. You're talking about verbal communication here. You're talking about state the document or condition of, state the content or condition of any document here. So you're talking about here, advocates are not allowed to produce any document to state the content or condition of any document. And the third one is actually to disclose any advice given by him to his client. And this is privilege as long as this three communication here is made in the course and for the purpose of his employment as an advocate. Right? Okay, bear in mind that the rationale of this particular provision here is to enable full disclosure by the client to allow for an effective advice in legal matters. So that is what stated basically in the case of Anwar Ibrahim, Datuk Sri Anwar Ibrahim number 3. Yeah, so that will be the rationale of this one. However, you have to bear in mind that the privilege of professional communication here is accorded to the client, is not given to the solicitor. So it is protection that is given at all time to the client, and the protection here remains to be given to the client even though the lawyer is no longer employed as advocate and solicitor representing the client. So you have, okay, if you look at this particular notes here, you find that what are the conditions that has to be satisfied? Number one, there must be a professional relationship between the advocates and his client, right? So the professional relationship is a prerequisite for any other possible disclosure. So it means that if there is no professional relationship, if you are not employed as an advocate and solicitor for your client, then there will be no according of this privilege communication. Okay. And number two is that there must be, okay, the principle of professional privilege here, there's an issue whether the principle of professional privilege here coextensive with the principle of privilege. Now what happened here is that, so you have section 126 of the Evidence Act that accords you with professional communication between the lawyer and his client. And of course, number one, okay, bear in mind, of course, there are three kinds of protection that is accorded. That is, there must not be any disclosure of communication. Number two, there must not be disclosure of any document. There must not be disclosure of any advice made by the solicitor to the client, right? And the prerequisite element that you have to fulfill, basically, there must be professional relationship of solicitors and client in this context. And when we talk about this one, so they have an issue whether the professional relationship here, must it come together with confidentiality or not? What happens if you have a situation where, say you have, right, the client here and you have the solicitor here. So the solicitor is having a communication or making an advice for the client. So what happened here is that the client disclosed this particular communication made with his solicitor to a third party. Can now in court the client here claim privilege? Right? So that will be the issue. Now there have been different approaches as to regard whether privilege and confidentiality must exist coextensively. There have been cases to say that you have this in the case of Ernest Cheong Yong Yin, you have it in the case of Dr. Clearance, which say that for there to be privilege, it must also have the element of confidentiality. So there have been one case to say that they have, for privilege to occur, it must also have confidentiality there. However, there have been other cases, like the case of Dato' Anthony C, says that privilege and privilege and confidentiality does not exist together. It does not coexist together. So it means that, because according to the case of Dato' Anthony, the principle of one's privilege is always privilege here does not accord any relation with confidentiality, right? So that is what stated in the case of Anthony C, right? Okay, that is the position. Now, when you have that, so what you have here now, basically, so you have a solicitor and client here having a relationship of professional relationship. So then, whatever communication they may have, it is a confidence communication. And one of the elements that you have to bear in mind is that since the protection is actually given to the client, you have to ask the question, when will it last? Yeah, when can the protection given to the client last? Right? How long does the privilege last? So basically, you have quite a number of cases to say that when the communication is privileged, it will remain privileged. It means that the communication between the solicitor and the client will be privileged even after the death of the client. So it is the protection given to the client. Therefore, even if after the death of the client, the privilege will remain. Okay? And remember, the privilege is not to protect the solicitor, it is to protect the client. And what happens if there is no more relationship between the solicitor and the client? It means that whatever transpired, as long as it is made during the course or for the purpose of employment, then the communication will remain privileged. So that is the law indicates. Yeah. So basically, how long will the privilege last? So number one, it will be lasting as long as possible. It means that even after the death of the client. And number two, the privilege even continues after employment ends. It means that whatever communication that exists between the two persons during the course of employment as an advocate will be privileged. Okay? Now, if you read again section 126 here, you'll find that there is basically a situation where privilege is not accorded. So this is a situation where privilege is not allowed. Yeah? So you have the first part of the section that is providing you with three situations where privilege is accorded. And then you have provided that nothing in this section shall protect from disclosure. So this particular provision provides you that, okay, you have section 126 here provides you this protection in three kinds of disclosure: the communication, the document, and the advice given by the solicitor to the client. And this protection, however, is not given in situation where, right, no protection from disclosure shall be given in situation where you have any communication made in furtherance of illegal purpose. So any communication made in furtherance of illegal purpose. So this situation, the protection is not accorded, right? Another situation where you read section 26 subsection 1 subsection B, 1B here, any fact observed by any advocate in the course of his employment as such showing that any crime or fraud has been committed since the commencement of the employment. So what happened here in the second part here, you have a situation where the solicitor here or advocate here is already appointed by the client. Now what happened here is that after appointment as a client, the solicitor observed that a crime has been committed or a fraud has been committed. Then in that situation, there will be no longer privilege. Yeah, there will no longer be privilege. Yeah. So, in the situation of the first one here, furtherance of illegal purpose. So it means that you have been employed. You have the solicitor here being employed by the client And after that, after appointment, the client here is actually committing a crime, right? So, furthering an illegal purpose. So, for the purpose of commission of something that is illegal, right? The case that you can refer to will be the case of re-detention of Leonard Teo. Now, what happened in the case of re-detention of Leonard Teo? This is actually a very high-profile case. If you recall last time, you have Aisha, yeah? The client, this is something related to constitutional issues on right to religion, yeah? So basically what happened here is that you have Aisha here. Aisha here is a Muslim who converted to Christianity. Okay, she has basically a boyfriend who is a Christian, and then when she converted, the family didn't know about that. So what happened here is that she actually ran away together with the boyfriend, and this is actually noted by the lawyer. So the lawyer knew about this, and in that situation, so when Aisha followed the boyfriend here, so you have here the parents of Aisha unhappy about the matter, so they reported this to the police. So the police is now investigating under kidnapping, right? So this is regarded to be a kidnapping cases. Now what happened in this case is that, right, Leonard Teo, which is the lawyer here, has been asked to disclose whatever communication. So you have the detainee here, Leonard, was asked by the prosecutor, right, by the authority, to disclose whatever communication that he may have with Aisha. And in this case, yeah, the lawyer here is claiming privilege. However, the court in this case says that the privilege accorded under section 126 subsection 1 here will not apply in this case, because this is a case where this situation involves criminal matters. So the police is now investigating matters relating to kidnapping, which is an offense under the law. So under section 126 subsection 1b, there will be disclosure has to be allowed. So there must be disclosure on this information, right? So basically this is an example where protection of privilege under section 126 here, right, is actually not accorded by section 126. So there will be no privilege in such communication. Therefore, disclosure has to be made. Okay? All right. Basically, that will be generally the law on privileged communication, professional communication. Okay. So you have that just now. Okay. So we have discussed this one, the three situations where privilege is accorded under section 126. Yeah. And then we also have discussed about, right, instances where privilege is not accorded. All right. And then, okay, besides section 126, we have section 127. Section 127 is an extension of section 126. It refers to any official that is working together with the professional authority, professional just now. Yeah, so you have section 126 to apply to interpreters, etc. Section 126 shall apply to interpreters and the clerks or servants of the advocate. So this particular provision is actually an extension for the protection given to the client under section 126, whereby privileged communication that is accorded to the lawyer, to the advocate and solicitor is basically extended to the staff, which are the interpreters, the clerks or servants of the advocates and solicitors. Yeah, so that will be the position under section 126. And again, we have other forms of privileged communications. You have that in section 128, yeah, 129, 130, and 131. This will be giving you matters relating to other privileged communication between the parties. Yeah, and of course section 132, which talk about privilege against self-incrimination, which has been discussed in the previous video. All right, so with this I end up the discussion on witnesses related to matters on privilege, competency, compellability and privilege. The next discussion that we are going to have relating to witnesses will be regards to the issues of corroboration.